Hey everyone, welcome here all. So today we are going to understand directive principle of state policy. So today we'll be learning what Indian policy has talked about directive principles of state policy in the simple language possible. So let's read. The directive principle of state policy are enumerated in part 4 of the Constitution from Article 36 to 51. So this is the important point to mark then exactly in which part directive principle is settled. And what are the articles that talks about the directive principles? The framers of the Constitution borrowed this idea from the Irish Constitution of 1937, which had copied it from the Spanish Constitution. So, as we all know, the Constitution is often known as the borrowed way because most of the provision has been inherited from the other countries. So, just like that, keeping the trend, the ethic principles of state policy is also borrowed from Irish Constitution. But again, even the Irish Constitution has borrowed this from Spanish Constitution. But we don't need this information. But it's good if we know that. But we need to remember the directive principle of state policies is taken from Irish Constitution. Dr. B.R. Ambedkar described this principle as novel features of the Indian Constitution. This is again an important point to note down. Which part of the Indian Constitution is described as the novel features of Indian Constitution and by whom? So, by B.R. Ambedkar, it is said that the ethic principle of state policy is the novel features of our Indian Constitution. Then we have the directive principle along with the fundamental rights contain the philosophy of the constitution is the soul of the constitution. So DPSP and fundamental right is along known as the soul of the Indian constitution. Granville Austin has described the directive principle and the fundamental rights as the conscience of the constitution. So as I said in many of my videos, if you are preparing a note, so always try to give reference and statement of famous person. So if you are preparing a note on directive principle of state policy, in the beginning of the answer you can write that Granville Austin has described directive principle of state policy as the conscience of the constitution. As such, like other scholars has remarked this. Even one statement from the famous figures will do some good. So let's move into features of the directive principle. As we all know, features is all about a person. If we talk about a person, it's how the person looks like, how he talks, is he thick, thin, he has hair or not. So these are kind of the features. So when we talk about directive principle of state policy or any such topic, features is exactly the same kind of uh, you know gestures or bodily what do I say bodily parts that define that the very topic. So let's move. The phrase directive principle of state policy denotes the ideals that the state should keep in mind while formulating policies and enacting law. That it says that the principles of state policy. So these are some of the principles that have been wasted upon the state while making any particular law, and they have to keep that in mind. These are the constitutional instruction and recommendation to the state in legislative, executive, and administrative matters. It says these are the some instructions that the states needs to follow. According to Article 36, the term state in Part 4 has the same meaning as in Part 3 dealing with the fundamental rights. So, fundamental rights, we have the definition of state. The same definition will be applied here too. Therefore, it includes the legislative and executive organs of the central and state governments, all local authorities, and all other public authorities in the country. So, Article 12 talks about the state, what makes a state, and the same definition will be applicable here. The directive principle resembles the instrument of instruction enumerated in the Government of India Act 1935. So, it is given by the Act of 1935 and it is known as some of the kind of instrument that the state needs to follow. In the words of Dr. B.R. Ambedkar, the directive principles are like the instrument of instructions which were issued to the Governor General and to the governors of the colonies of India by the British government under the Government of India Act of 1935. So what you can do, you can write down the famous figures, person's name and write down the statement they have given regarding the directive principle of state policy. So if you can collect at least 5 to 10 of the statements, your answer will be automatically be ready. So try to take out the information that is necessary to put into your answer. What is called directive principle is merely another name for the instrument of instruction. So this is another nickname of directive principle of state policy, which is known as instrument of instructions. The only difference is that they are instruction to the legislature and the executive. So these are the only one particular difference that it has. Directive principle constitutes a very comprehensive economic, social, and political program for a modern democratic state. So, directive principle of state policy is basically established with the thought that it will promote growth of the country as a whole. It will take along all the people with it towards a modern and welfare country. They aim at realizing the high ideals of justice, liberty, equality, and fraternity as outlined in the preamble of the Constitution. So, this particular point is the aim of the directive principle of state policy. So, this is an also important point to note it down. What is the aim of the directive principle of state policy? They embody the concept of a welfare state and not that of a police state, which existed during the colonial era. So, back then we were under the British rule, and their model was mainly police state, not a colonial, not a welfare state. They were like mostly dadagiri. The police were superior. People had no voice. So this kind of happenings were there back then. But now that the constitution has evolved, the people have evolved, or the British has gone, the directive principle of state policy is more focused towards a welfare state. In brief, they seek to establish economic and social democracy in the country. So this paragraph is basically, it mainly talks about the aim of the directive principle of state policy. You can note it down in bullet points also. The directive principles are non-justiciable in nature. That is, they are not legally enforceable by the courts for their violation. So here the important point that we need to remember, that is non-justiciable and justiciable. So they are not justiciable in nature because they are some kind of principles that the states are requested to follow. If they do so, it will be very good for all of us. But if they don't do so, then also you can sue them in the court because they are not justifiable, non justiciable in nature. They don't have any legal force. There are some kind of instrument principles that based on morality does impose upon the state, and the state is said to follow them. Therefore, the government, central, state, and local, cannot be compelled to implement them. Nevertheless, the Constitution Article 37 itself says that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply this principle in making law. So, it's all about the features. The directive principle, though non-justiciable in nature, help the courts in examining and determining the constitutional validity of a law. So this is the role of directive principle, how it helped the Supreme Court. This answer is resides in this particular line. The Supreme Court has ruled many a time that in determining the constitutionality of any law, if a court finds the law in question seeks to give effort to a directive principle, it may consider such law to be reasonable in relation to Article 14, equality before law. 19. So basically, this talks about in order to implement the directive principle of state policy. If there is a law and it is kind of getting well with fundamental right, and the law, the main reason behind bringing the law is to implement the directive principles of state policy, then it will be known and it will be regarded as constitutional and not violative of the constitutional morality. Classification of the directive principle. Though our constitution doesn't talk about the classification, it basically mentions all of that principle in a manner. But if we talk about this particular book, there is a classification that has been mentioned. The constitution, so the classification mainly bases on socialistic, Gandhian, and liberal intellectual. Socialistic principle. This principle reflects the ideology of socialism. They lay down the framework of a democratic socialist state, aim at providing social and economic justice, and set the path towards welfare state. They direct the state. So it says to promote the welfare of the people by securing a social order permitted by the social justice, economic and political, and to minimize inequalities in income, state facilities and opportunities. That is Article 30. So many of the words you will be already have seen in the preamble itself. To secure the right to adequate means of livelihood for all citizens, the equitable distribution of material resources of the community for the common good, prevention of concentration of wealth and means of production, equal pay for equal work for men and women, preservation of the health and strength of workers and children against possible abuse and opportunities for healthy development of children, to promote equal justice and provide free legal aid to the poor as Article 39A. So basically, free legal aid is for those people who can't afford a lawyer when there is a particular case they're concerned with, so they can ask for free legal aid. But the sad reality is many don't know the procedure, or many don't know that such kind of thing also exists, and people rarely visit them to inquire about the proceedings. To secure the right to work, no education, assistance to cases of employment, old age, sickness, and disablement, Article 41. So these are the kind of a article and their statement, and that has been classified into socialistic Gandhian and liberal intellectual on the basis of the context they have. Let's move into Gandhian principle. This principle is based on Gandhian ideology. As we all know, we seen in the Munna Bhai MBPS that अगर कोई देश काल पे चाटा मारे तो दूसरे काल भी we should offer. So that kind of ideology is kind of Gandhian principle, and as we all know, Gandhi played a very important role in the independence era. So some directive principle is also classified into Gandhian principle. They represent a program of reconstruction initiated by Gandhi during the national movement. In order to fulfill the dreams of Gandhi, some of his ideas were included as directive principles. They required the state to organize village panchayats and endow them with necessary powers and authority to enable them to function as units of self-government. So there is this saying that says that Gandhi or our India's ideology is resides near the rural areas or near the gaon mein basta hai. So this kind of thoughts have been incorporated in order to keep the Gandhi's dream alive. Promotes cottage industries on individual or corporation basis in the rural areas, so basically to what do I say, to grow the people who lives in village area and to promote them towards a higher authority so that they can also uh, contribute themselves. Promote voluntary formation, autonomous functioning, democratic control, professional management of cooperative society. To promote an educational economic interest of SCs, STs, and other weaker sections of society, and to protect them from social injustice and exploitation. So this is basically to bring all the people together despite their classification, they are SC, ST, or tribal areas, or the people who are in the weaker section. So it was Gandhi's dream to merge all the people in an equal position. To prohibit the consumption of intoxicating drinks and drugs which are injurious to health, so that our youth doesn't get destroyed in their very young age itself. To prohibit the slaughter of cows, calves, and other milch and draught cattle, and to improve their breeds. So basically, we need to preserve or safeguard those animals who gives us some kind of food, be it milk, be it the kind of product that we get from milk. So this is our duty to keep them safe and to look towards their good health. Then we have liberal intellectual principle. This is third category in this manner. The principle included in this category present the ideology of liberalism. They direct the state to secure all citizens a uniform civil code throughout the country. That is one nation, one rule. So a perfect example would be this, that marriage registration. In India, we have different laws for different religion. We have Hindu Marriage Act, we have Sharia law. All kind of religion has been governed by the personal law itself. But one thing that is common, that is the registration of marriage, which has been implemented recently, and this is incorporated in order to bring the people together, and there should be uniformity among all. To provide early childhood care and education for all children until they complete the age of 6 years. So the education is necessary in order to make the country grow. So this has been made compulsory, and this has been classified under liberal intellectual principle. Then we have to organize agriculture and animal husbandry on modern and scientific line. So if we talk about the earlier age, the people were not that much developed because there is no education, no science, no development. But now that we have, so it is kind of suggested that people should do their harvesting, people should do farming with scientific method for better growth. Then we have to protect and improve the environment and to safeguard forest and wildlife. So it is our duty to safeguard our forest and wildlife for our generation and for also us to breathe a more fresh air. To protect monuments, places, and objects of artistic or historic interest which are declared to be national importance. So it is also our duty to keep the particular monuments, places, and objects safe for our again for our future generation and to keep our heritage rich in nature, to keep our culture rich in nature. To separate the judiciary from the executive in the public services of the state. As we all know, there is independence of judiciary. All the three organs is separated from each other, so there is no autonomy that can be practiced. So these are classified into liberal intellectual principles. Then we have to promote international peace and security and maintain just and honorable relation between nations to foster respect for international law and treaty obligation and to encourage settlement of international dispute by arbitration. So this is basically Article 51, which talks about peace, international peace and security. So now let's move towards new directive principles. The 42nd Amendment Act 1976 added 4 new directive principles to the original list. So it can again be asked how many directive principles have been incorporated by the 42nd Amendment Act, and it says to secure opportunities for healthy development of children, to promote equal justice and to provide free legal aid to poor. Article 99A to take steps to secure the participation of workers in the management of industries, to protect and improve the environment and to safeguard forests and wildlife. So this has been incorporated later in the list of directive principles. The 44th Amendment Act of 1970 added one more directive principle which requires the state to minimize inequalities in income, status, facilities and opportunities, that is Article 38. The 86th Amendment Act of 2002 changed the subject matter of Article 45 and made elementary education fundamental right under 21A. So the changes have been made and it has been made as the fundamental right of the children to receive education, and this has been made by the year of 2002. The amendment directive requires the state to provide early childhood care and education for all children until they complete the age of 6 years. Then we have the 97 Amendment Act of 2011. It is a new direct principle relating to cooperative society. It requires the state to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative society under Article 43B. Now let's talk about sanction behind directive principle. Sir B. N. Rao, the constitutional advisor to the Constitutional Assembly, recommended the rights of an individual should be divided into the categories justiciable and non-justiciable. This was accepted by the drafting committee. As we all know, directive principles are non-justiciable in nature. They can't be enforced in court. Consequently, the fundamental rights which are justiciable in nature are incorporated in part. Directive principles which are non-justiciable in nature are incorporated in part of the Constitution. FR is justiciable and DPSP is not justiciable, and they are both incorporated in the Constitution systematically. And though the active principles are non-justiciable, the Constitution Article 37 makes it clear that these principles are fundamental in the government of the country. It should be initially the duty of the state to apply these principles in making laws. Though it says they don't have a legal binding, but it is said the state should adhere to it while making any new law. Thus, they impose a moral obligation on the state authorities for their obligation, but the real force behind them is political, that is public opinion. As observed by Aladhi Krishna Swami Iyer, no ministry responsible to the people can afford light-heartedly to ignore the provisions of Part 4 of the Constitution. Again, you can write down the name and your statement regarding the sanction behind directive principles. Then, based on the statement, you can write the rest of your answer. Similarly, Dr. B. R. Ambedkar said in the Constitution Assembly that a government which rests on popular vote can hardly ignore the directive principle while shaping policy. So, it says there are some principle, but people believe if the state should adhere to it, the state should always keep in mind while making any particular new law, and that should be their first preference. So let's move towards criticism. A very beautiful thing about Indian polity is it has the criticism features salient features, and this is a very important thing to add in your answer. So it says no legal force. As I said, it is not binding. If the state is doing their work, it's very good for our welfare state. If they are not listening to it, then also we cannot sue them in court because they are non-justiciable in nature, and it has been said already. Then we have illogically arranged. Some scholars believe the directive principle is not arranged in a proper manner. Somewhere, some have very deep meaning, whereas the next principle that has been incorporated has less meaning or not that much important in comparison to the one that has been prescribed before. Then it says conservative. According to Sir Ivor, Jainik directives are based on the political philosophy of the 19th century England. So it was made when the England was ruling us, and it says it is conservative in the words of Sir Ivor Jennings. So all the kind of criticism that has been mentioned here has been given by any particular jurist or philosopher or advisor. So you can write down the exact line and who are the people who have given their opinion to it, and that will make your answer more heavy in nature. Then we have constitutional conflict. Keith Santhanam has pointed out that it led to a constitutional conflict between the center and the state, between the president and the prime minister, and between the governor and the chief minister. According to him, the center can give direction to the state with regard to the implementation of this principle, and in case of non-compliance, dismiss the state government. So this is the statement by K. Santhanam that he believes that the principle creates constitutional conflict among these particular people. So let's move towards utility of dialectic principle. Despite the criticism, despite the misarrangement, despite the non-justification, at the same time, we also have some good benefit it brings to us. So, in spite of the above criticism and shortcomings, the direct principles are not an unnecessary appendix of the Constitution. The Constitution itself declares that they are fundamental to the governance of the country. According to L.M. Singh, an eminent jurist and diplomat, the directives are the life-giving provisions of the Constitution. They constitute the staff of the Constitution's philosophy of social justice. M.C. Chagla, former Chief Justice of India, is of the opinion that if all these principles are fully carried out, our country would indeed be a heaven on earth. So such big statement has been given by the Chief Justice of India. India would then be not only democracy in the political scene but also a welfare state looking after the welfare of the citizens. Dr. B. Ambedkar had pointed out that the directive principles have great value because they lay down that the goal of the Indian polity is economic democracy as distinguished from political democracy. So this is basically the people who talks about or who talks for the uh, in support of that principle of state policy. According to still with the former Attorney General of India, the directive principle, although confer no legal rights and create no legal remedies, are significant useful in the following way. So these are the kind of points that has been given by MC Sattleworth that how this is important for us to keep in the Constitution itself. So let's move towards conflict between fundamental right and directive principle. So there is a conflict that has been happening between the fundamental rights and the directive principle of justice policy because one is justiciable, the other one is non-justiciable. But if the directive principles starts to lessen the value of the fundamental rights, can it be happening? Can fundamental rights can be amended? So these are all kind of question that has that strike upon. So a famous case has been mentioned here, that is Champakam Duraidhan case. The Supreme Court ruled that in case of any conflict between the fundamental rights and the direct principle, the former would prevail. So it says the fundamental rights is more powerful in comparison to the directives of state policy, or it is more fundamental in nature. It declared that the directive principle have to conform to run as subsidiary to fundamental rights, but it also held that the fundamental rights could be amended by the Parliament by enacting constitutional amendment. So these are some of the cases that has been mentioned where the Supreme Court has talked about which one is superior in comparison to whom and how that will prevail. So now these are some of the distinctions that has been given here. Fundamental rights and directive principles. These are very simple. If you know what directive principles are, what are fundamental rights are, you can create them by their own. They are negative as they prohibit the state from doing certain things. So they prohibit the state, so they cannot make any law which will take away their fundamental rights. These are positive as they require the state to do certain things. Then we have their justiciable, this is non-justiciable. They aim at establishing political democracy in the country. They aim at establishing social and economic democracy in the country. These have legal section, these have moral section, and they promote the welfare of the individual, hence they are personal individualistic, and they are uh, based on the collective interest of the society. They do not require any legislation for implementation, they are automatic and full, just like you know, the auto renewal scheme that we get, and they get once you feel the pay for it, once you pay for it, then after a period of time the trial will finish and it will automatically get renewed, so just like that. But these are not like that. The courts are bound to declare a law validity of the fundamental rights as constitutional and invalid. The courts cannot declare a law validity of any of the Directive Principle as unconstitutional and invalid. However, they can uphold the validity of a law on the ground that it can enact it to give effect to a directive. So these are basically some of the case law that has been given here. It's Minerva Mills case. Then we have Kesavananda Bharati case. Then we have Golaknath case, when it says the parliament can do anything but cannot touch the basic structure of the doctrine. So, what is the basic structure of doctrine, which I have already explained in my videos. So, this is basically the clash between the parliament and the legislature. That what are the parts that can be amended by the parliament, and is parliament superior in comparison to the legislature? So this answer has been answered here. So that's all for today. In today's video, we have tried to cover the directive principle of state policy. If you find this video worth watching, do like, share, and subscribe. So it will motivate me to bring just more updates. So that's all for today. See you in another video.